Hello friends, in this video I am going to discuss about Article 13 only. So what is Article 13? So basically Article 13 is restriction on the power of the state. So while making any law, while making any policy, state cannot takes away or abridge, or states cannot touch any of the fundamental right. So this is basically putting restriction on the power of the state, and this is basically safeguard given to part 3 of the constitution, that is fundamental rights. So when I'm talking about Article 13, so Article 13 is basically given in two parts: pre-constitutional law and post-constitutional law. When I'm talking about pre-constitutional law, so basically it is based on the commencement date of the constitution, and the commencement date of the constitution is basically, we all know, 26 January 1950. Okay? When I'm talking about the pre-constitutional law, so there are several pre-constitutional law. Like if you will see Indian Contract Act 1872, Transfer of Property Act, CPC, these all are made before the commencement of the constitution. So Article 372, I'm talking about 372. 372 saying, okay, several law has been made by the Britishers only. This whole system has been created by the Britishers only. So we cannot abolish the whole system. Rather, we have to accept those things which is going within the spirit of the constitution. So Article 372 is giving safeguard to those laws which has been made before the commencement of the constitution. So when I'm talking about all the law which has been made about before the commencement of this constitution, they are still in force. Still, when you are learning Indian Contract Act in 1872, it has been made in 1872 by the Britishers only. When I'm talking about Transfer of Property Act, it has been made by the Britishers only in 1882. When I'm talking about the Civil Procedure Code, it has been made by the Britishers only in 1908. But where is the written provision? Because we are the law student, we have to see one thing only. We have to prove one thing only, that something which is in practice is written in somewhere. So when I'm talking about the law, all the law which are still applicable, which has been made by the Britishers only, how they are applicable? So they are applicable by way of Article 372. But when I'm talking about Article 13 subclause 1, so basically when I'm talking about this Article 372, so Article 13 subclause 1 is the proviso of Article 372. And why I'm saying that Article 13 subclause 1 is the proviso to Article 372? Because when all the law before the commencement of this constitution shall be continued according to Article 372. But what Article 13 subclause 1 is saying, that all the law before the commencement of this constitution are still in force, but they will become null and void to the extent if they are going against the fundamental rights. So if they are within the spirit of the constitution, if they are not going against right to equality, if they are not going against right to freedom, if they are not going against right to exploitation, right, religious right, then still they can be applicable. But if they are going any of the fundamental rights, so they will become null and void by way of Article 13 subclause 1. Second thing which I am talking about is Article 13 subclause 2, and that is basically direct restriction on the power of the state. So when I'm talking about the post-constitutional law, so in according to Article 13, Article 13 is saying that state shall not make any law which takes away or abridges of any of the fundamental right. Like for example, today is 2nd August 2026, and if a state is making any law which is going against right to equality, right to freedom, or any of the fundamental right provided in Part 3 of the Constitution, so the state shall not make any law. Okay. If we are putting some restriction, so we must have got some remedy also, because according to UPSS AB remedium, if you are saying that you have got certain right, so basically there will be certain remedy also. So when I'm saying that, okay, Article 13 saying that the state shall not making any law which will go against the fundamental right. But what if a state is making any law and that is going against fundamental right also? If a state is saying, okay, from tomorrow all the girls will sit at the home and they will not go for the study. Okay, from tomorrow all the boys shall sit at the home, they will not go for a study. All the boy need not to cook the food, all the girls will cook. So these law are basically based on the discrimination. No society will accept, no democratic society will accept these law. And if state, because the state has got the power to make the law, if any government in full majority they can make any law, so what will happen then? What is the protection given? So basically the judicial review is the direct protection. When I'm talking about the state is making any law which is going against the fundamental right, a state is making any policy which is going against the fundamental right, though what will happen? Then we can directly approach to the Supreme Court or the High Court, and Supreme Court shall directly review that act has been done by the judiciary itself. So when I'm talking about Article 13, Article 13 is basically talking about three things: pre-constitutional law, post-constitutional law, judicial review. And for a doctrine of eclipse and doctrine of severability, I will make separate videos. Thank you.